Today on Legalese, we are talking about the case of the National Rifle Association versus Vullo. Hey, greetings everybody. Welcome back once again to Legalese. As always, I am your host, Bob, and I want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me especially welcome you. This is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, I just want to remind you guys real quick, you can find out more about us by checking out our homepage over at legalespodcast.com. And if you want to stay up to date whenever I put out any new content, and I don't just do these videos on YouTube, I do articles on Substack, I do an audio-only version of the show, I post to alternative platforms. And if you want to get notifications for all of those things or just curated content for some of those things, either way, you just have to go head over to legaleseshow.com. There you can subscribe to our newsletter, sign up, and let them know what content you want to get notifications on, and they will be sent directly to you. All right, well, as always, we have a hell of a lot to get to today, so why don't we just jump right in? So, back on November 15th, I would add the case of NRA versus Vullo to my Supreme Court Roundup. Now, this case actually has a lot in common with the Murphy case that we have been covering extensively the last few weeks. And in fact, they were so similar in that they're both cases of government censoring through the practice of jawboning that the Supreme Court actually heard oral arguments in Murphy and Vullo last Monday, March 18th. And so the oral arguments in this case today came immediately following the oral arguments in Murphy v. Somewhere.
I'll be deep in the cold, cold ground before I recognize Missouri.
All right, before we get to the merits of the case and the oral arguments, let's just do a very quick review of the facts of the case and the procedural history in the lower courts. So, starting with the basic facts of the case. So, in Vullo, the National Rifle Association, our nation's oldest civil rights organization, alleged that a New York official violated the group's right to freedom of speech by urging banks and insurance companies that worked with the NRA to cut ties with the group. Now, this dispute dates back to 2017 when the New York Department of Financial Services, which oversees banks and insurance companies in the state, opened an investigation into insurance programs endorsed by the National Rifle Association to provide coverage for injuries caused by guns. And in 2018, 3 companies would acknowledge that some of the programs endorsed by the NRA violated state law. These companies agreed not to provide any NRA-endorsed insurance programs to New York residents and to pay fines ranging from $1.3 to $7 million. Now, of course, as we all know, back in February of 2018, the NRA would personally perpetrate a mass shooting in Parkland, Florida, in which they murdered 17 students and staff. And it was for this reason that the head of the New York Financial Services Department, Maria Vullo, would issue a press statement and guidance letters in which she called on banks and insurance companies doing business in the state to consider the risks of doing business with the NRA or other organizations that personally perpetrate mass executions of innocent children. This would include people like the GOA, FPC, and the Second Amendment Foundation, which, as we all know, are the literal perpetrators of 137% of all mass shootings in the country. If you're asking yourself how it is that a legal person with no agency can commit a statistically impossible number of mass shootings, stop being so cynical. Just recognize that everything anti-gun groups say about these organizations must be true. So when several insurance companies would stop doing business with the NRA and some other banks withdrew their bids for the group's business, three insurance companies were coerced into signing letters of consent, which were legally binding and kept them from ever doing any business with the NRA or any gun rights organization. And with that success under her belt, Maria Vullo would further encourage all other banks and insurance agencies in New York to join their colleagues and boycott the NRA, while the NRA would go to court, where it would sue Vullo, arguing that she had violated the group's right to freedom of speech by threatening the companies and banks so that they would break off their relationship with the group. All right, let's move on to talking about the procedural history in the lower courts. So, a federal district court in Binghamton, New York, would allow the NRA's First Amendment claims against Vullo to go forward. Senior U.S. District Judge Thomas McAvoy concluded that when viewed together, Vullo's statements could be interpreted as a veiled threat to regulated industries to disassociate with the NRA or risk action by the Department of Financial Services. Now, on appeal, the U.S. Court of Appeals for the Second Circuit would reverse McAvoy's ruling, and they would hold that the NRA had failed to plausibly allege that Vullo had crossed the line between attempts to convince and attempts to coerce. But in any event, the Court of Appeals would conclude that Vullo was entitled to immunity because the law governing the NRA's First Amendment claim was not clearly established. And it was with that the NRA would come to the Supreme Court in 2023, in February of 2023 to be exact, and asking the justices to grant review on this case. And they would agree to take up this case on the merits back in November of 2023. And with that, we get to the merits of the case before the Supreme Court, and then we will be discussing the recent oral arguments in this case. So, in its brief on the merits, the NRA stresses that Vullo could not directly penalize the NRA because she disagreed with its support of gun rights. Now, they say that although she could have criticized the NRA or reminded insurance companies and banks about their legal obligations without violating the First Amendment, they observed that the Supreme Court ruled in 1963 in the case of Bantam Books v. Sullivan that informal, indirect government efforts to suppress or penalize speech by threatening private intermediaries violates the First Amendment. And on those grounds, the NRA contends when Vullo used her power over these banks and insurance companies to get them to blacklist the NRA, she violated the First Amendment. Now, under past Supreme Court precedent, the NRA suggests that there are three factors that are relevant to determining whether a speaker crosses over to coercion or inducement. All three of those factors, the NRA will contend, lead to the conclusion that Vullo did indeed violate the group's First Amendment rights. So the NRA explained that it is the government's official power over individuals or entities that is at issue, and that is what she is addressing here, because the NRA says that Vullo acts as what they call the sheriff of Wall Street, and that she had authority to do everything from investigate these banks and insurance companies to revoke their license and even refer them for criminal prosecution. A second factor the NRA would note is the content or purpose of the government's official communications. In this case, the NRA emphasizes that Vullo went beyond simply expressing her opinion about guns and instead both threatened companies that did not comply with her political blacklist and offered inducements to those who did. And then the third and final factor here is the effect of the government's conduct on its target audience. And here, The banks and insurance companies that Vullo was charged with regulating would have obviously heard her message loud and clear. The NRA charges that, with many either cutting ties with the NRA or withdrawing bids they had submitted for the NRA's business, this shows a clear step past persuasion to coercion and inducement. So the the counsel, I should say, for the NRA, David Cole, would essentially state that any efforts by the courts of appeals to downplay the significance of Vullo's conduct on the grounds that the NRA was unpopular in New York, so that doing business with the group carried a reputational risk, would effectively bless a heckler's veto. The NRA warns of potentially expansive implications for such a rule. Although it might be clear the way for government officials to target groups for the favorable views of gun promotion, the group observes, in other states, it would permit government officials to target pro abortion groups on the same grounds. Now, this point that the NRA is making is more than an abstract hypothetical. Some of you may remember when I made a video discussing Texas's SB 8. This was their legislation that allowed individuals in Texas to act as private attorneys general and bring suit against any doctor who performed an abortion. Now, I warn people here on this show that some gun hating dicks could very easily turn around and create legislation based on this, allowing people to sue on behalf of victims of gun violence. And about a month later, after I made that prediction, Gavin Newsom introduced legislation in California to create a cause of action against anyone who manufactures, distributes, or sells a modern sporting rifle or a ghost gun kit in California. Now, as I mentioned earlier, this case was heard right after Murphy v. Missouri, and here too, the federal government, represented by Ephraim McDowell, the assistant to the Solicitor General.
I don't want to have to deal with it.
And that's why you have an assistant regional manager.
Yes, it is. Assistant to the regional manager.
Same thing.
No, it's not. It's lower. So
It's close.
Even though they weren't an official party to the case, the Solicitor General's office did file an amicus brief in this case and a motion for leave, which the court would approve, which gave the Solicitor General a chance to present their brief that was filed as an amicus curiae in this case in support of neither party. Now, Joe Biden, pictured here, holding an invisible gun he is about to use to shoot an invisible person after shaking their invisible hand, suggests a middle line. And so his U.S. Solicitor General Elizabeth Prelogar told the justices in her brief that the NRA's allegations about Vullo's February 2018 meeting with Lloyd's of London, at which Vullo supposedly pressured the insurance companies to end their relationship with the NRA because she disagreed with the group's position, states a claim for a violation of the First Amendment that should be allowed to go forward. But the Solicitor General says other steps by Vullo, such as enforcement actions against insurance companies, do not provide the basis for a First Amendment claim because they were based on bona fide violations of New York law and therefore also consistent with legitimate law enforcement efforts. And it just so happens that the argument that the federal government is making here goes precisely as far as this case could go to fully vindicate the NRA, while also allowing the federal government to go scot-free in the Murphy case. Now, in her brief on the merits, the respondent, Maria Vullo, who was represented here, well, among others, but represented before the Supreme Court by the former acting Solicitor General, Neil Cat Yowell, and she would urge the court to dismiss the case. She argues that the justices lacked the power even to decide whether Vullo had violated the First Amendment because the Second Circuit ruled that Vullo was immune from suit. Apparently, Vullo doesn't know how lower courts work. Anyways, because the Supreme Court, Vullo says, did not take up the immunity question, she even further contends that its ruling on a First Amendment question, therefore, would be purely advisory and would have no effect on the judgment below. Now, that's ridiculous. And if the justices move on the merits of the NRA's arguments, Vullo has another argument where she contends that they don't even need to consider whether Vullo's acts were coercive. Because most of the NRA's allegations, at least she reasons, focus on steps that Vullo took to enforce New York law for which she is entitled to absolute immunity, such as executing a consent order or foregoing enforcement of additional violations as part of a negotiated solution. So, Vullo's claim is that she was simply regulating the insurer's conduct rather than retaliating against the NRA's speech. And under the Supreme Court's cases dealing with claims of First Amendment retaliation, she contends that the NRA must show that her decision to take action against it was objectively unreasonable, which she says the group cannot do. Now, she argues, especially with the insurer's acknowledgement in consent decrees, that both they and the NRA had engaged in illegal conduct. But in any event, Vullo would further say that the NRA has not adequately alleged her statements were coercive. She says that industry letters and the statements that Vullo issued after the Parkland shooting did not so much as hint that insurers or banks would suffer any adverse consequences for maintaining ties with the NRA, and although critical of the NRA, she says her tone was even-handed and non-threatening, and therefore she concludes that they are not remotely comparable to the thinly veiled threats to institute criminal proceedings that was the basis for Bantam Books. Now, Vullo also echoes the Second Circuit's suggestion that because the decisions by the banks and insurance companies to cut their ties with the NRA in 2018 are best attributed not to her speech or her enforcement actions, but instead to, quote, a groundswell of public pressure against the NRA, in quote, in the wake of the Parkland shootings, and she cautions that a ruling for the NRA would set an exceptionally dangerous precedent. The government, she warns, won't be able to work properly if public officials can't freely express their views, and a prosecutor can, as in this case, be held liable for violating the First Amendment simply by expressing her views on a matter of public concern and her acts enforcing New York law against parties who conceitedly violated it. And so let's just, before we get to the oral arguments, do a quick refresher on the questions presented before the court in this case. All right. So there are two questions presented here. One, does the First Amendment allow a government regulator to threaten regulated entities with adverse regulatory actions if they do business with a controversial speaker as a consequence of A, the government's own hostility to the speaker's viewpoint, or B, a perceived general backlash against the speaker's advocacy? And two, does such coercion violate a clearly established First Amendment right? And with that, let's get to the oral arguments that were heard before the court this last Monday, March 18th. So, the first thing to note is that the Supreme Court on Monday appeared very sympathetic to the National Rifle Association's claims that a New York official had indeed violated this group's right to freedom of speech when she urged banks and insurance companies that worked with the NRA to cut their ties with the group. During what was just over an hour of oral arguments, the justices from all ideological sides here all seemed inclined to allow the NRA's claim to go forward. Now, representing the NRA in court was David Cole of the American Civil Liberties Union, and I was very surprised to see him representing them in court.
Well, you good folks can rest easy now because you've come to the very best in legal representation.
Excuse me, is there an Orange Julius stand on this floor?
I'll sell you this one. It's almost full.
Well, why don't I drink out of a toilet bowl?
He'll be back. And as for your case, don't you worry. I've argued in front of every judge in the state, often as a lawyer.
Now, the reason I was surprised to see the ACLU representing the NRA in this case, and I think this may have actually a big effect on the case, is because there is a very complicated history between these two groups. There has been a certain animosity towards the NRA from the ACLU since at least 2008, when the NRA played a key role in the DC versus Heller case, in which the Supreme Court would identify the Second Amendment as an individual right. Now, the ACLU, back around then in 2008, used to take the position that the Second Amendment was a collective right, and they were just kind of all sour grapes over the fact that the court chose the right interpretation. And the ACLU would respond to that case by sort of lashing out at the NRA and the so-called gun lobby. Then, back in 2021, the ACLU took the position the Second Amendment wasn't a right at all. And this was something I covered back then in an article published by the Libertarian Institute called All Gun Control is Racist, which I'll link to on the show notes page. But I discussed how the ACLU had come out and said in an open public statement, the Second Amendment isn't a right at all. It's a manifestation of white supremacy and anti-blackness. Now, recently, they have seemed to soften their tone, and they have, as far as I can tell, returned to their prior belief that the Second Amendment is a collective right. But as they just made clear only 3 weeks ago, they think the NRA are basically a pro-murder organization. And I'm not kidding here. So they issued a press release just a few weeks ago on March 3rd of 2024, in which they deeded this case while simultaneously trashing the NRA, their client, as an organization. So turning to that statement, they say the ACLU disagrees sharply with the NRA on many issues, yet we are representing the group in this case because of the First Amendment principles at stake. We argue that Maria Vullo, a New York state regulator, threatened to use her regulatory power over the banks and insurance companies to coerce them into denying basic financial services to the NRA, and in Vullo's own words, other gun promotion groups. Vullo's threats were expressly based on her disagreement with the NRA's advocacy, and they worked. Several insurance companies and banks refused to work with the NRA out of fear of reprisals from New York regulators. The ACLU urges the Supreme Court to hold that coercing third parties to break ties with the NRA because of its advocacy violates the First Amendment. But it goes on. Even those who oppose government censorship may be sympathetic to New York's effort to shut down the NRA. The NRA is dedicated to promoting guns, which plays an outsized role in violence and death in this country. The ACLU does not support the NRA's mission. In fact, we directly oppose the NRA and support the government's power to adopt sensible tools like public carry permits and disarming persons subject to domestic violence protection orders. While it's understandable that Vullo wanted to address the gun violence epidemic, government censorship wasn't a constitutional response to that problem. Now, reading something like that makes me wonder, when your own attorney trash talks your organization, why the fuck do you have them representing you? Especially when the NRA actually had some other fantastic lawyers on their legal team, including the great Eugene Volokh, who is one of the country's greatest living First and Second Amendment scholars. He's also the founder of the fantastic Vullo conspiracy blog. He's a member of the Supreme Court Bar. He has argued several cases before the court in years past, and Eugene has had countless amicus briefs cited as vital and decisive evidence in numerous Supreme Court cases over the years. So I don't know why the NRA would send up a guy from a group that hates them. But anyways, personally, here's the important bit, I think. Personally, I think this obvious tension with the ACLU and NRA came through during the oral arguments because I really think, frankly, David Cole did a really shitty job.
So, Mr. Nahasapima Petalon, if that is your real name, have you ever forgotten anything?
No. In fact, I can recite pi to 40,000 places. The last digit is 1.
Pi.
Well, if you never forget anything, tell me this. What color tie am I wearing?
You are wearing a red and white striped club tie in a half Windsor knot.
Oh, I am I? Is that what you think? Well, if that is what you think, I have something to tell you. Something that may shock and discredit you. And that thing is as follows. I'm not wearing a tie at all.
But if I am wrong about that, maybe I am wrong about Mrs. Simpson.
No further questions.
However, in spite of their shitty lawyer, what the New York Department of Financial Services actually did in this instance was just turned out to be so horribly fucked up and corrupt, I don't see how the NRA can lose.
Ladies and gentlemen of the jury, who do you find more attractive? Tom Cruise or Mel Gibson?
What is the point of all this?
Your Honor, I feel so confident of Marge Simpson's guilt that I can waste the court's time by rating the super hunks.
Ooh, he's gonna win.
Mr. Hutz.
Now, that's also the exact same impression I got from the oral arguments because the justices all seemed pretty sympathetic to the NRA's position during the session. Now, David Cole, the attorney for the NRA, would characterize the case as a straightforward application of the court's 1963 decision in Bantam Books v. Sullivan, holding that informal, indirect government efforts to suppress or penalize speech by threatening private intermediaries violates the First Amendment. In this case, he said, Vullo's actions were not about enforcing insurance law or mere government speech. Instead, Cole would stress that the case centers on a campaign by the state's highest public officials, the highest political officials, to use their power to coerce a boycott of a political advocacy organization because they disagreed with its advocacy.
We'll hear argument next in Case 22-842, National Rifle Association versus Vullo. Mr. Cole.
Mr. Chief Justice, and may it please the Court. Government officials are free to urge people not to support political groups they oppose. What they cannot do is use their regulatory might to add "or else" to that request. Respondent Vullo did just that. Not content to rely on the force of her ideas, she abused the coercive power of her office. In February 2018, she told Lloyd's, the insurance underwriter, that she'd go easy on its unrelated insurance violations if it aided her campaign to weaken the NRA by halting all business with the group. Lloyd's agreed. 6 weeks later, she issued guidance letters and a press release directing the thousands of banks and insurance companies that she directly oversees to cut off their ties with the NRA, not because of any alleged illegality, but because they promote guns. In the accompanying press release, Vullo's boss and co-defendant, Governor Andrew Cuomo, said he directed Vullo to issue the guidance because doing business with the NRA, quote, sends the wrong message, unquote. Shortly thereafter, Vullo extracted legally binding consent orders from the NRA's 3 principal insurance providers, barring them from ever providing affinity insurance to the group ever again, no matter how lawfully they do so. These actions worked, as multiple financial institutions refused to do business with the NRA, citing Vullo's threats. This was not about enforcing insurance law or mere government speech. It was a campaign by the state's highest political officials to use their power to coerce a boycott of a political advocacy organization because they disagreed with its advocacy. Governor Cuomo essentially conceded as much in 2 tweets responding to this lawsuit, in which he said, and I quote, "The regulations New York put in place are working. We're forcing the NRA into financial jeopardy. We won't stop until we shut them down. It's time to put the gun lobby out of business. Hashtag bankrupt the NRA." At the motion to dismiss stage, the only question is whether these allegations, taken as a whole, plausibly plead a First Amendment claim. Because Vullo chose coercion over persuasion, they do. I welcome the Court's questions.
Now, representing Maria Vullo before the court was Neil Katyal, who countered that the key fact in this case is the conceded illegal conduct. The insurance companies and the NRA, he says, were selling an illegal product. The obvious explanation for Vullo's behavior in this case is that she was enforcing the law, and if the court allows the NRA's lawsuit to go forward, he cautioned that it would allow others to bring lawsuits to block valid enforcement actions.
Thank you, counsel. Mr. Katyal?
Thank you, Mr. Chief Justice, and may it please the Court. The key fact in this case is the conceded illegal conduct. As Justice Sotomayor said, the 3 insurers and the NRA broke the law. They were selling intentional criminal act insurance, and all of the products they offered were unlawful because the NRA refused to get a license. That's why Bantam Books is miles away from this case, and it's why the court below found qualified immunity protects Vullo. In this posture, Iqbal demands courts ask, as between the invidious coercion asserted or the obvious explanation she was enforcing the law, is coercion plausible? When illegal action is present, the plausibility burden is higher. To use Mr. Cole's phrase, the government is more likely responding to conduct than, not speech, and 4 separate doctrines explain why. First, Iqbal held plausibility rules are, quote, especially important in suits where government defendants assert qualified immunity because they must be neither deterred nor distracted from vigorous performance by disruptive discovery. Second, the presumption of regularity is at its height. Third, absolute immunity protects enforcement actions. And fourth, causation is more difficult. That is particularly so after Parkland, which led many businesses that Ms. Vullo has no control over, such as United Airlines and Avis Cars, to sever ties with the NRA. Were this court to accept this thin complaint in the teeth of the conceded illegal conduct, it would empower strike suits to enjoin valid enforcement and open sensitive discovery. That's why the court's traditional test here is right. A government official crosses the line from coercion to persuasion when, 1, when they are threatening as opposed to encouraging, and 2, there is no objectively reasonable basis for their action. The NRA can't meet that test, and that's why they are seeking to weaponize the First Amendment and exempt themselves from the rules that govern you and me simply because they're a controversial speaker. I welcome the Court's questions.
Now, Justice Samuel Alito would press David Cole to better define coercion. And Alito would describe what he talked about as a spectrum, with threats of legal action at one end as an example of very clear coercion, and at the other end, a scenario in which a government official does not have any power but suggests that a person or entity should do something. And in between, Alito continued, there are a lot of different gradations, particularly when the official who makes this request has the power that Ms. Vullo had over these organizations, and the entity or person of whom the request is being made knows that the official has this power. Just as Alito said, I am sure that these insurance companies were well aware of the power Ms. Vullo wields.
Justice Alito?
On the question of the meaning of coercion, I can think of a spectrum. On one end of the spectrum, a government official says, look, suppress this speech, and if you don't do it, I have legal weapons I can use against you, and I'm going to punish you using those. That's very clear coercion. At the other end, the government official who has no authority to do anything for any practical purposes to the entity that the government official is speaking to says, you should do this, it would be a good thing to do, you'd be a good citizen if you did it. And in between, there are a lot of different gradations, particularly when the official who's making this request has that power, and you have to assume that the person or the entity to whom or to which the request is being made knows that, just as I am sure that these insurance companies were well aware of the power of Ms. Vullo. So how do you define when it goes too far along that line?
So I do think that the power of the official over those to whom she is speaking is a relevant factor in the assessment. But the assessment is, at the end of the day, would a reasonable person in this situation feel that the government is coercing it, that it is implying some sort of threat of action against it, of adverse action against it. So the mere fact that someone exercises regulatory power over you, I don't think is sufficient. But when combined with what you have here, explicit requests to punish a group because of its advocacy, and the invocation of the very tools she has to make life miserable for them, you're not managing reputational risk. We might fine you, or, you've got these technical insurance infractions. We might go after your partners and require them to never provide you affinity insurance ever again. This is on the first end of the spectrum that you identified, Justice Alito. So I agree there are hard cases in the middle, and that's true with any standard that at the end of the day looks at coercion. In the context of confessions, coerced confessions, there are some hard lines to draw. This one is not.
Okay. The Solicitor General urges us not to consider the enforcement actions against Lloyds, Lockton, and Chubbs and the consent decrees, and it argues that the district court held that those actions are entitled to absolute prosecutorial immunity, and petitioner has not challenged that holding here. Do you want to comment on that?
Yes, thank you. Respondent never asserted absolute immunity with respect to the Bantam books, the First Amendment claims in this case. Absolute immunity was only asserted with respect to a separate selective enforcement claim. They chose, with respect to the First Amendment claims, to only assert qualified immunity. That's number one. So it was not asserted below. It was not asserted in the Court of Appeals. It was not raised in the bio. It's not appropriate for this Court to decide at this stage.
Thank you.
Now, one question that the justices grappled with was which of Maria Vullo's actions, if any, are relevant to the NRA's First Amendment claim. Now, the Biden administration had urged the justices to focus on the group's allegation about Vullo's 2018 meeting with Lloyds of London, at which Vullo supposedly pressured the company to end its relationship with the NRA.
Thank you, counsel. Mr. McDowell?
Thank you, Mr. Chief Justice, and may it please the Court. Government officials may criticize private speech that they deem harmful and persuade citizens not to support that speech. But government officials may not threaten to take adverse action against private parties to coerce those parties into penalizing a disfavored speaker. Taking petitioner's allegations as true, that is what respondent did here. In the Lloyds meeting, she explicitly threatened to bring an enforcement action against Lloyds unless Lloyds, quote, ceased providing insurance to gun groups, especially the NRA, close quote. The Court should find a straightforward First Amendment violation under Bantam books, but in recognizing the First Amendment claim here, the Court should take care to avoid suggesting any new limits on the government's ability to speak to the public or its ability to provide ordinary legal guidance to regulated entities. I welcome the Court's questions.
Though Justice Samuel Alito was clearly still all worked up from the very upsetting and disturbing aspects of the federal government's arguments that had taken place just minutes earlier in the Murthy case, and he would continue pressing them balls to the wall as they tried to argue their amicus brief in Vullo as well.
So does that mean that really the New York officials could have achieved what they wanted to achieve if they hadn't done it in such a ham-handed manner? So instead of having the meeting with Lloyd's they just gave speeches about the terror, about guns and how bad the NRA is, and they spoke about social backlash against guns and those who advocate for gun rights in the wake of the terrible Parkland shooting. But in all of that, they don't mention anything about any regulatory authority. And then after harping on that for a while, then they make general statements about the importance of every insurance company taking into account reputational risk. And then they sit back and they see whether that's achieved the desired result. Basically, that's what your position is, isn't it?
No, Your Honor. Well, we're primarily.
If what they did was what I just outlined, would that be a violation of Bantam Books?
Probably not, because there would be an attenuation between the invocation of legal consequences and the instruction or the message. And we think the first 4 paragraphs of the guidance letters standing alone are permissible government speech, because those 4 paragraphs involves criticisms of the NRA and urging third parties not to support the NRA. That's the classic form of government speech that falls within longstanding tradition. President Reagan expressly criticized the KKK and urged citizens not to support or associate with the KKK. That's what the first 4 paragraphs are doing.
Well, and if they had said everything in those first 4 paragraphs in some other format, it would be a different matter. But this is a guidance letter.
I take the point
that
they
understand what a guidance letter is about, right?
I take the point that the fact that it's in a guidance letter is highly unusual. You would expect to see this in an op-ed or a press conference. And that is a factor, I think, in going to the implicit coercive analysis. But without the 5th paragraph, there's no invocation of an adverse action at all. So the first 4 paragraphs standing alone, although unusual, would still be permissible government speech.
Yeah, so they gilded the lily, or whatever the phrase is. I mean, they were ham-handed about this. The people up in New York are rubes. They don't really understand how to do this. If you do it in a more sophisticated manner, you can achieve what you want to achieve.
I don't know, Justice Alito, because I don't know that insurance companies and banks would feel that their will was overborne or that they were really at risk of experiencing adverse action in your hypothetical. That's the question. Are the parties able to exercise their own independent judgment?
I mean, seriously, you think that sophisticated insurance companies are not taking into account adverse risks? They probably had heard about the Parkland shooting and the aftermath of it. You think they hadn't already taken this into account? And didn't they already know all the power that Ms. Vullo had over them?
And then, just like in the Murthy case, Samuel Alito and Neil Gorsuch got the representative from the Solicitor General's office to contradict himself and argue something other than what the government had briefed in this case, which was pretty impressive to see them just demolish 2 different attorneys from the SG's office. Now, this had to do with the guidance letter that Maria Vullo had sent out, which the Biden administration had argued was not coercive. Then, in court, their representative said that most of it wasn't coercive, but the last paragraph was.
They certainly knew about the authority that DFS had, but without any invocation of that authority and a tying of that authority to a specific instruction like we have in the guidance letters, I don't think we would get to coercion.
You agree, though, the 5th paragraph changes the calculus.
Yes, Your Honor, but I want to say something to make it very clear. We think that this has to be considered alongside the press release and the tweet. We think that's one unit of governmental communication. So we would not look at the guidance letters alone. And we would look at the guidance letters particularly as a way to reinforce the allegations about the Lloyd's meeting rather than considering the guidance letters as a standalone matter.
And why? Now, on the other hand, David Cole, the counsel for the NRA, would encourage the justices to take a broader lens here, contending that the most significant harm to the NRA is that the Department of Financial Services continues to maintain on its website these guidance letters, which essentially put, as he puts it, a scarlet letter on the NRA with respect to every bank and insurance company in New York, and that these should be taken down.
Favor.
Yeah.
And certainly you don't want to be limited on remand to arguing just the Lloyd's incident as your case.
Well, that's right. I mean, I think right now the most significant harm to the NRA is that the DFS continues to maintain on its website these guidance letters, which essentially put a scarlet letter on the NRA with respect to every bank and every insurance company in New York. Those should be taken down. So we would urge you, both for purposes of guidance to others and because it matters to the ultimate remedy in this case, to address the meeting with Lloyd's, the guidance letters, and the subsequent enforcement action. And the other thing I would say about the meeting with Lloyd's is it was in private. It was in private. So NRA might have suffered some damages vis-a-vis Lloyd's with respect to that meeting, but the real damage in terms of the putting the scarlet letter on the NRA comes from her public actions and Governor Cuomo's public actions to issue these guidance letters. So I would urge you to address the whole picture here, to reinforce Bantam Books, and to reverse on the merits.
Thank you.
Now, Neil Katyal, representing Maria Vullo, would take the opposite stance. Of course, he agreed that the court should absolutely look at all the different conduct together, but he would contend none of the different pieces of evidence standing alone added up to something that's coercive, and that, even together, they still don't add up to something that's coercive.
So our position here is that the court should absolutely look at both of the, all of the different conduct together. We think any one of them individually doesn't add up to something that's coercive, and together they don't add up to something that's coercive. The other point I'd like to make, and this goes back to Justice Alito, to your points about Iqbal and Twombly, the standard about at the pleading stage. I think it's relevant to note that in Twombly itself, there were two alternative explanations for what was going on with these big behemoth companies. One was that they were conspiring and illegally agreeing to divvy up the market. The other was that they made individual determinations on their own to do that.
Now, David Cole, counsel for the NRA, would also push back against Maria Vullo's contention that the case should be dismissed because the Supreme Court was not reviewing the lower court's conclusion that Vullo was entitled to qualified immunity, so that any ruling on whether Vullo had violated the group's First Amendment rights would not affect the lower court's judgment. If the court reverses the ruling by the Court of Appeals and holds that the NRA has stated a First Amendment claim, Cole reasoned, it should send the case back to the Second Circuit to reconsider its ruling on qualified immunity, which Vullo has said is inextricably intertwined with the First Amendment question.
Yeah, thank you. No, this court did not divest itself of jurisdiction when it granted the case and asked for briefing on only one of the two questions presented. If the court reverses on the First Amendment ground, it would be totally appropriate to send it back to the Second Circuit to reconsider the qualified immunity question, which is, as respondent herself argued in the Second Circuit, inextricably intertwined with the merits determination. The court's assessment of the merits here is basic disregard of what happened at Lloyd's. It's adopting every inference in favor of Vullo and against the NRA with respect to the guidance letters. All of that infected not just the merits determination, but the qualified immunity determination. So the court has jurisdiction over the case. It can reverse on the question it took up, and then it can ask the Second Circuit.
What about the injunction?
And as to the injunction, it was no final. There was no final order. There's no final judgment, and so we have the right to appeal that, and we will appeal that when there's a final judgment. This was an interlocutory appeal from a qualified immunity holding only, so we had no obligation to cross-appeal.
Now, at the very end, David Cole would have a chance for a rebuttal statement, and he would close by telling the justices that the notion that this is business as usual for a government official to speak with a private party and say, we'll go easy on you if you aid my campaign to weaken the NRA, that this is not business as usual, and that these are not ordinary plea negotiations.
Exactly what he said. They want them out of the case because they demonstrate the impermissible motive. Carry guard. Carry guard is a red herring here. The carry guard program was suspended by Lockton's and the NRA in November 2017. Everything else, everything that we're talking about here happened after November 2017. Her meeting with Lloyd's. Lloyd's did not underwrite carry guards. And her meeting with Lloyd's says, cut your ties with gun groups, especially the NRA, because I'm trying to weaken them. Gun groups don't have carry guard. Only the NRA did. It wasn't even operative at that point. The guidance letters say nothing about carry guard. This is not a guidance letter about insurance infractions. This is a guidance letter about the NRA and other gun promotion organizations. The NRA's insurance was not all illegal. No, the NRA didn't have an insurance license in New York because it's not an insurance company. Nor does the ABA. Nor does the American Ophthalmologist Association. But they all have affinity insurance, and it's just run by brokers, as Justice Sotomayor said, in New York. That's perfectly legitimate. There were some infractions in terms of how it was marketed, how the compensation structures that were actually quite commonplace in the industry, and she enforced them against them and not against others. Finally, the notion that this is business as usual for a government official to speak with a private party and say, we'll go easy on you if you aid my campaign to weaken the NRA. That is not business as usual. That is not an ordinary plea negotiation, and nor is the guidance letter.
Thank you, counsel. The case is submitted.
Now, while it's not entirely clear exactly where each justice shakes out on every issue, a majority of the justices seem to agree with Cole. And in fact, I would say all of the justices agreed with Cole to some extent. It's really just a matter of how far they're willing to take their willingness for this claim to go forward. Do they do it just on the meeting with Lloyd's of London? Do they also do it on the the guidance letters? Just how far do they go? That's really the only thing up for debate here. But the decision in this case, of course, is expected by this summer, and there is, in fact, I think it's pretty decent chance here that we see the court reverse the circuit court 9-0, at least on a limited basis. So, again, as we heard, the U.S. Solicitor General has offered up a middle path in which they claim that what most of the government did here was fine. I think there's a chance that we may see the more liberal justices, Sotomayor, Kagan, and Jackson, maybe go with that middle path approach. And so we would have 9 judges to reverse, but we may have something like 6 judges to reverse on all claims and 3 judges to reverse on some claims. But either way, things are looking very good here for the NRA. And, that's actually really all I have for you guys here today. Thank you so much for tuning in to Legalese. Now, before you go, if you would please just do those things for me that help to trigger Al Gore's rhythm. If you like this video, take a moment, you hit that like button. If you disliked it, you can hit the dislike button. I'd very much prefer if you hit the like button, but, you have agency, you have free will, you can do what you want. But, also don't forget to subscribe to the channel, click that notification bell so you always know when I put new content out. And make sure to share the show. That is a really, really great way you can help the show for free. Just take a moment and either share this episode to your social media, or think of a friend or two who might find the show interesting or useful and send it to them. And if you would do those things for me, I would very much appreciate it. Now, a couple days ago, last Wednesday the 20th, another case from my Supreme Court Roundup, Gonzalez v. Trevino, was argued before the court. So in the next couple days here, you guys can be expecting another video from me going over the oral arguments in Gonzalez v. Trevino. So that's when you want to make sure you subscribe to the channel so you get an update when that comes out. That's going to be a great video. Be looking out for that. And until next time, this has been Bob for Legalese, talking about the NRA. And of course, as always, Carthago delenda est.